Judiciary Committee will come to order. Can you hear me? There we go. Okay. It is Monday, March 2nd, and the Judiciary Committee will come to order. There is a quorum present. I'm just going to remind folks of our committee decorum and expectations, and we'll be reading here from the script. We appreciate your interest and participation in the legislative process. To ensure everyone can view, hear, and understand today's proceedings, we ask for your cooperation in maintaining decorum and civility throughout this hearing. For the safety, security, and comfort of all attendees, please note the following guidelines. Signs and placards are not permitted in the hearing room. Verbal outbursts, shouting, or disruptive behavior will not be tolerated. Disruptive conduct may lead to the removal of those engaging in the behaviors. Applause or other audible demonstrations are not allowed. For safety reasons, everyone must be seated. No standing, sitting, or pacing in walkways or aisles, and no standing or obstructing at your seat. If you require a reasonable accommodation, please speak with our sergeant staff. They are identifiable by the gold badges on lapels and suit coats and will be present throughout the hearing and are here to ensure everyone's safety. Thank you. And the first bill on our agenda today is Senate File 3583. Senator Putnam can come forward.
Thank you, Madam Chair. I promise I was paying attention.
Whenever you're ready, Senator Putnam.
Thank you, Madam Chair. Today, and members, today I'm presenting for your consideration Senate File 3583, which is a bill relating to farmer-lender mediation, which has passed unanimously through the Agriculture Committee, and this is its next stop. So again, I appreciate your time and your attention to this matter. Folks, as many of you probably know, it's a really, really hard time to be a farmer in the state of Minnesota. Being a farmer is a challenge anyway when you are at the behest of weather and foreign trade and all kinds of other issues over which you have no control. And lately things have become even that much more challenging in ag land. And we are seeing a rapid increase in the number of potential defaults between farmers and their lenders. Members, 40 years ago, at the height of the farm crisis, a program was started in Minnesota called Farmer-Lender Mediation. And it's a process whereby farmers are sat down with their banks and they have a nice long conversation about how to keep in farming and how to keep paying their bills. That program started at the height of the farm crisis in the 1980s. We are at that moment again, where the crisis facing agriculture and facing farmers is so extreme that the challenges being faced by the Farmer-Lender Mediation Program are becoming more intense. The need is increasing as this program is set to sunset. Right now, we're looking at 3 to 4 times as many farmer-lender mediation meetings this year as we had in past years. And let's be clear, well, the way this works, if you have debt of over $15,000 and your bank is about to put you in default or foreclose upon you, you can automatically participate in this program. And this program has worked 90% of the time. 90% of the time, this program has enabled farmers to keep farming and bills to keep getting paid. It's an incredibly important program. And so, Madam Chair, the bill you have before you simply removes the current sunset and gives another 5 years to this incredibly important program in a moment where it is essential. Madam Chair, that's the bill in its entirety. It's very brief, it's very simple, but it's also extremely important.
Thank you. And you have a testifier here, Gary Wertish from the Minnesota Farmers Union. You can come forward. Just begin by stating your name and title for the record.
Well, Madam Chair and members of the committee, my name is Gary Wertish. I'm president of Minnesota Farmers Union. I live in Renville, where we now rent our farm to one of our sons, and I've been honored to serve in this role since I was elected in 2017. I'm here to share our strongest support for Senator Putnam's Senate File 3583, which would extend Minnesota's farmer-lender mediation program. At our state convention in November, our members defined our top priority as responding to the economic crisis in farm country. And from that, a top ask of our state agriculture committees was extending and strengthening our state's mediation program. Put simple, this program saves farms, and I could probably say saves lives too. Since the 1980s farm crisis, when this program was first created, when a lender seeks to enforce a debt against the farmer has the right to choose mediation, And it's important to note, too, that it doesn't take any rights of the lender away. The lender still has his rights that he signed with his agreement. So it just slows the process down a little bit. And that's important because it gives some breathing room for farmers when they've had in what might be the worst months of their career. They work with a trained team to assess options and come up with a mutually agreeable solution. Last year, nearly 90% were able to come to a resolution. In our members' experience, this might mean selling off some land or another tough decision, but in many cases, it means they can keep farming. It is also important to note that the mediators work with the Minnesota's farm advocates and others to help make sure farmers have the support they need. In the best of times, farming is a stressful job, and these are far from the best of times. Requests for mediation are increasing as are the farm bankruptcies. From the weather to markets to tariffs to input costs, there's so much you don't control, and that creates a lot of uncertainty. So we appreciate your work to ensure that the state is doing everything it can to create certainty in this important program work. Again, thank you for this work, and I hope this extension earns your full support.
Thank you. And I know you mentioned this, but the requests for mediation have increased. Was it doubled, or what was the percentage again?
It depends on how you count. I'm sorry, Madam Chair. It depends on how you count, 3 to 4 times as many.
Okay.
It's a significant increase, a massive increase.
Thank you, Senator Putnam. Are there any questions, members?
Madam Chair.
Senator Westrom.
Madam Chair, Senator Putnam, could you tell us how many mediations there's been in the last 2 years?
Senator Putnam.
Madam Chair, Senator Westrom, I can give you a ballpark. I hope that's adequate, Senator
Yeah,
Westrom.
that's
but
fine.
I think it's about 300 per year.
Okay.
I've seen numbers, and they vacillate between 200 and 400, which is why I hesitate, Madam Chair, when you asked earlier for an exact number of the increase, it depends on how far back you go over the course of the past 5 years. I think last year was 282, but Senator Westrom, I know it's somewhere in that ballpark.
Sure. And
Senator Westrom.
Madam Chair, Senator Putnam, I know we're all kind of familiar with this farmer-lender mediation program. This being the Judiciary Committee, I'm wondering if you could explain how the mediation works, and when does the farmer get their notice of the right to mediation so that they have ample time to impose their right under state law?
Madam Chair, Senator Westrom, I could fake an answer, but we have an actual expert here. Madam Chair, if you wouldn't mind.
And Madam Chair, I'm just trying
Yes, Senator
to
Westrom.
give Senator Putnam a little flavor of the Judiciary Committee. So, no, and maybe a more serious question. As the mediation, and I should have asked this in Ag Committee, but does the guarantee of the mediation, the farmer get to pick the mediator, or is it only the farmer and the banks using the state farmer lender mediators? Or is that just one of the options farmers get, or is the state farmer lender mediators the only ones that really work in this program? And maybe Mr. Wordish knows if you don't.
Madam Chair,
Senator Putnam.
Madam Chair, Senator Westrom, those are all fantastic questions. I will say just at the outset, one of the great things about this program is it does have the enthusiastic support of lenders. So you'll see in your packets quite possibly a letter from Ag Country, and the same letter is signed as well by Compeer. Those are the people, those are the banks that are sitting down with the farmers in the first place, and they very much support this program. In terms of the actual day-to-day operation of it and how it works, to get to your curiosity, Senator Westrom, we do have Whitney Place from University of Minnesota Extension, who oversees that program, who is here with us now. And she, Madam Chair, if you're interested, she could talk us through the actual processes on a more granular level than I would be able to.
Very good, thank you.
Yeah, thank you for being here with us. Whitney Place, if you want to just begin by sharing your name and title.
Thank you, Madam Chair. My name is Whitney Place. I'm the Director of Government Affairs for University of Minnesota Extension. Senator Westrom, to your question, the mandatory portion of mediation for this program is just the notice. So they send a notice of mediation to farmers who creditors are able to collect on. And That does not mean that the farmers need to take part in that mediation. In fact, last year, 992 notices were waived, and the lender and the farmers just worked it out on their own. And so not all notices end up in a mediation. In terms of who selects the mediators, we have mediators across the state, so it's mostly geographical, or which mediator has time to dedicate to whatever mediation is needed. So farmers don't necessarily select them. It's selected by our program in terms of capacity and where they are located geographically.
Senator Westrom?
And Madam Chair, Ms. Place, a little more to that program. Is it really the program that is in place that lends itself to the mediations happening or occurring at a zero or no cost to the farmers? Or what do they pay? And if you didn't have the program, would there be other mediation available if the farmers or lenders chose for it? And then who would pay for that? If you can talk a little bit about the pay of this program, and do we not have the mediations if we don't have your program in place, or is that just a piece of the mediation that goes on out there?
Ms. Place?
Madam Chair, Senator Westrom, mediations could still take place if this mandatory portion of the program wasn't extended. However, we think this is a good opportunity for farmers and lenders to identify issues within an operation and come to the table. And we do think that it has kept farms in business over time. And so the program is funded by the state and federal government at the University of Minnesota Extension. And without that support, the program wouldn't exist. So that's where the funding comes from.
Senator Westrom?
Very good. Last question, Ms. Place. So hypothetically, if we didn't have the program and we extended the sunset, what would be in place then? Just a notice to the farmers, and then they and/or the bankers, lenders would have to contract with another private source of mediators? And I guess coupled with that question, does anybody ever do that, or does the farmer and lender mediation program you work with cover 100% of the defaults or farmer lender mediation requests in the state? Just questions that I'm thinking about as we kind of dig into this extension, and good to know.
Ms. Place?
Madam Chair, Senator Westrom, yes, without this program, farmers and lenders could go into their own mediations, but I assume there would be a cost to that, and these are already farms who are in financial trouble. And so the program not having a cost therefore allows them to have access to that conversation with the lender.
Any other questions, members? Okay. Do you have a motion for us, Senator Westrom?
Madam Chair, if there's no other discussion, I would move that the Senate file be referred to, look to you for guidance on where does this?
To higher ed.
Committee? I would move to refer the Senate file to the Higher Ed Committee.
Thank you. Senator Westrom moves Senate File 3583 be recommended to pass and re-referred to higher ed. All those in favor, say aye. Aye. Any opposed? Okay, motion prevails, and Senate File 3583 is on its way to higher ed. Thank you, Senator Putnam.
Thanks much.
Okay, next we'll go to Senator Pappas, Senate File 3791. Whenever you're ready.
Good morning, Madam Chair and members. I have the A1 Authors Amendment, and is that already in your packet? Oh, great.
It is, yep.
So the author's amendment comes from the real property section of the Minnesota Bar Association. It's meant to ensure clear title by providing that a defective postponement affidavit does not invalidate the foreclosure, and I would move the A1 amendment.
Senator Pappas moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Any opposed? The motion prevails and the amendment's adopted.
Madam Chair, Senate File 3791 makes it clear that the right of the homeowner to postpone a mortgage foreclosure sale applies in two specific circumstances where there has been legal ambiguity. It also clears up confusion regarding the length of a redemption period when a homeowner postpones a foreclosure sale and then files for bankruptcy. Finally, the bill makes clear that if the homeowner dies, the heirs have the right to postpone the sale and retain the home. By way of brief background, in 2009, during the foreclosure crisis, the Minnesota legislature passed a bill to help homeowners save their homes from foreclosure by allowing them to postpone the mortgage sale. In Minnesota, prior to the sale, a homeowner needs to come up only with the amount in arrears plus costs and fees to reinstate. After the sale, the homeowner must come up with the entire remaining balance of the mortgage. This is called redemption. The statute we're amending today was intended to extend the period in which the homeowner can reinstate. This law has helped innumerable homeowners keep their homes. Lenders and homeowners agree alike that it's far better to give the homeowner every opportunity to keep the house and continue the mortgage payments than have the lender end up with the house. We're here because three circumstances have arisen where it's unclear whether the homeowner's right to postpone applies. The first is the situation where the lender has first postponed the sale. The second is the situation where a homeowner has postponed the sale, reinstated, or redeemed, but in the future falls into foreclosure and the lender has to start the process all over again. The third is the situation where the homeowner in foreclosure dies before the sale. So the bill before you clarifies that the homeowner has the right to postpone a foreclosure sale if the lender has already postponed, clarifies that heirs have the right to postpone a mortgage foreclosure sale if the homeowner dies before the sale, and it clarifies that the shortened redemption period after a postponement and a subsequent bankruptcy filing only applies for that foreclosure. The longer statutory redemption period applies in the new foreclosure. I want to thank Eric Cook for his collaboration, expertise, and help on this bill. Eric is a foreclosing attorney and is a member of the real property section of the Minnesota State Bar Association. I also want to thank the Minnesota State Bar Association, the Minnesota Credit Union Network, the Minnesota Land Title Association, Minnesota Realtors, and Bank-In, which provide recommended language, which we have adopted. And Mr. Cook is here today to testify. Also, Ms. Colleen Daly from Legal Aid, and Legal Aid took the lead on getting this done. We all know Ron Elwood and appreciate him. So, Matt, do you want to go first? Or?
I would defer to Ms. Daly.
Okay,
Thank
Ms.
you.
Daly, yeah, you can begin by just sharing your name and title.
Thank you, Madam Chair. My name is Colleen Daly. I'm a staff attorney at Mid-Minnesota Legal Aid, and I have represented hundreds of homeowners in foreclosure. So basically, this bill, Senator Pappas described it very well already, but postponement is a very good tool for a homeowner because it allows the homeowner to catch up or to get a loan modification. So it prevents the loss of the home. You know, most people, once the sale happens, their only option is to sell the house because it's too hard to come up with all the money to redeem. And so this expands the universe of who can postpone, extends it to heirs, and then it also clarifies opportunities for postponement that in the past had been sort of unclear. So I'm happy to answer any other questions, but that's basically the bill.
Thank you. And Mr. Cook, you want to begin with your name and title?
Sure. Thank you, Madam Chair, members. As Ms. Daly and Senator Pappas have mentioned, this bill is truly a good part of public policy. It is beneficial not only for homeowners who are in trouble and in foreclosure, but it is beneficial for lenders. perhaps more importantly, because lenders don't want to, as Senator Pappas mentioned, they don't want to end up with the property. Studies have all shown they take bigger losses, and they much prefer to see a homeowner reinstate the defaults, never be put in that position where they have to redeem after a sheriff's sale, and never have to refinance a new mortgage when they've got a foreclosure on their credit rating already. So this is a win-win. I hate to use that phrase, but it truly is in this case in a very small section of the foreclosure application. And the expansions, which have already been described here, are good steps to help clarify some ambiguities that may not appear on the face of the statute, but in practice on a day-to-day basis, they do make a big difference in both lenders and homeowners know what to expect. If a homeowner elects to postpone a sale, we need to know if that's going to be effective or not. The amendment that was mentioned here as kind of a safe harbor provision does provide a benefit for lenders and homeowners. It will allow for homeowners to be cut a break. Lenders are more likely to be motivated to honor a borrower postponement even if there are defects or maybe if it's even defective. Lenders, this is going to help clear up clouds on title down the road should something happen and they do end up with the house. So for all of these reasons, I support this bill and believe that it's good public policy. Thank you.
Yeah, thank you both for your testimony. Are there any questions, members? Senator Kroon.
Thank you, Madam Chair. Just a comment. It's a good bill. Thanks.
Madam Chair.
Yes, Senator Pappas.
Madam Chair, I would move that Senate File 3791 as amended be recommended to pass and sent to the floor. Thank you, Senator Kroon.
Senator Pappas moves Senate File 3791 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Any opposed? The motion prevails and Senate File 3791 as amended is sent to the Senate floor. Thank you. And we're going to move to Senator Westlin's bills. Can you remind me what you're doing first? Senate File 3602, is that right, Senator
The
Westlin?
electronic
Okay.
estate planning bills, yes. And I believe I have a couple of testifiers. Second here. Okay. Thank you, Madam Chair.
I just didn't know which one you were doing first.
Excellent. This is Senate File 3602, which is the Uniform Electronic Estate Planning Documents Act. We will recall that we heard a similar bill about wills, electronic wills in 2023. And we have adopted various statutes that allow electronic signatures, including the Uniform Transaction Act, Uniform Real Property Electronic Recording Act, remote online notarization, and then most recently, electronic wills. This bill would expand on the Electronic Wills Act by authorizing signatures, electronic signatures for other estate planning documents such as revocable trusts, powers of attorney, healthcare directives, and so on. This is a joint effort between the Uniform Law Commission and the Minnesota State Bar Association, and it has been modified to add state-specific statutory references and other changes that align with Minnesota law. And I do have two testifiers today and would like to, you guys can flip a coin to see who's going to.
I'll go first.
Okay, great.
Whoever wants to go first, if you want to begin just with your name and title for the record.
Thank you, Madam Chair. I'm Kim Lowe. I'm one of Minnesota's commissioners with the Uniform Law Commission. I'm also a business law attorney here in the state of Minnesota. As Senator Westlin commented, this is a joint effort between the Uniform Law Commission and the MSBA. She also alluded to the fact that a couple years ago, we passed the Uniform Electronic Wills Act here in Minnesota. The Uniform Electronic Estate Planning Documents Act was adopted by the ULC in 2022. So it's a recent act that's been added to the to the portfolio. It does supplement the Uniform Electronic Wills Act, which was enacted in 2023. So our timing works out. Since then, this act has been specifically enacted in 6 other states, including North Dakota, Illinois, Missouri, Oklahoma, Colorado, and the state of Washington. It's also making its way through other states right now. In the states that it's been enacted, it has been unanimous, and we think it's a good act for Minnesota, and we want to work with the bar to make sure we get it passed.
Madam
Thank
Chair, Madam Chair, my name is Cameron Kelly. I'm an estate planning attorney in Stillwater, Minnesota. I work with a lot of estate planning clients throughout the Minneapolis-St. Paul area. I'm a co-chair of the Probate and Trust Law Section Legislative Committee, and I'm familiar with this act. I want to thank Senator Westlin for authoring this bill and also this committee for hearing us today. The Electronic Wills Act got us part of the way there. And the problem, though, is that although we can sign a will, we can't sign all the things that we would typically sign at the same time as a will. So when we have clients in, we tell them it's just as important that we put these disability documents in place is that we would have this will for you to handle what would happen after you pass away. So specifically, a couple highlights: healthcare directives, power of attorneys can't be signed, or if we do sign them, there's no guarantee that a bank would accept them. There's no guarantee that a hospital will accept them, because there's no specific authorization in the law today to enforce those documents, to require them to be accepted. UEPDA, which is the Uniform Electronic Estate Planning Documents Act, addresses that. And it allows non-will documents, we call them non-testamentary estate planning documents in the Act, to be accepted. It allows them to be signed electronically, and it reduces the chance that they're going to be rejected by institutions, banks, hospitals, and so forth. This bill would allow those estate planning documents to be signed, witnessed, notarized, and retained electronically, and also require that they be accepted just as though they're a paper signed copy of those documents. Why this is important for Minnesota? One, I think that your average Minnesotan probably already assumes that an electronically signed estate planning document would be accepted. And second, this is an access issue. We have clients who often, not often, but frequently enough, are hospitalized and maybe can't get into our office to sign these things. And also, there are legal deserts in Minnesota. There are places where people simply can't get to an attorney without driving 2 hours. And this is going to help to provide access to Minnesotans. Thank you.
Thank you. I appreciate this. I know I just gave birth about 6 months ago, and we needed to update our will and healthcare directive. All of the forms are still in the process of doing that, but it can be hard too when you are taking care of a newborn and finding the time to meet with someone. So appreciate that flexibility for folks who may not be able to meet in person.
Yeah. Thank you, Madam Chair.
Any questions? Senator Westrom.
Madam Chair, Senator Westlin, just kind of the overall issues of concern about fraud, and maybe your testifiers can talk a little bit about what protections are in place. If I'm understanding this, it would now allow a will document to be signed and executed. I mean, maybe your clients go south for the winter. So as a practicing attorney, I could have them sign it even though they're down in the state of Texas or Arizona. Is that kind of my simple understanding? But then how do we just protect against fraud? Does it make it easier for that? And maybe just talk about that as kind of just general concern, because I imagine that's part of the biggest reason we've tried to keep it in person as long as we have.
Thank you, Madam Chair and Senator. I will answer briefly. We already allow for electronic wills, and I think I was the first person in Minnesota to do an electronic will, and it does require you to provide ID. Everybody, I think is on, if I remember correctly, is on video. There is a process of verification, but I'm going to allow Mr. Kelly to give some additional information. But just to be clear, we already do this for wills, and this would allow for the non-testamentary documents, the trust, the healthcare directives, those sorts of things.
Thank you, Senator Westlin. Mr. Kelly.
Thank you, Madam Chair. So this was a topic of conversation with the Electronic Wills Act as well. And one of the things that we pointed out at that point in time was that things like beneficiary designations can already be signed through the Electronic Transactions Act without any sort of basically security procedure. And with the wills, there's multiple witnesses, there's a 2-witness requirement, and then oftentimes there's a notary. And the requirements for a notary are actually pretty robust in the Notarization Act. This bill does address security procedures and a way for the signature to be verified and to determine whether it's the signature of the person who is purporting to have a signature act. A lot of times what we would use, even if it was a non-notarized document, would be something like a DocuSign or an Adobe Sign, which has an audit trail, which those audit trails help with the security as well, because once the document is signed, the audit trail will tell you when the document has been modified, when the document was signed, when it was signed by the witness following the person who signed the document, the power of attorney. So if I'm signing a power of attorney, it records when I sign it. It records when the notary applies their stamp, and so forth. And you see that in the audit trail. It also talks about testimony. So if I am signing a paper copy of a document, and I have a couple witnesses to look at it, probably the court's not going to see that until after I die. And there are will contests where people question whether a particular person did sign the will or didn't sign the will. And sometimes we even get like forensic handwriting specialists involved. And maybe your witnesses have passed away along with the testator. And so the same sort of challenges present themselves with electronic documents, but this allows for testimony on the signature process the same way that you would have that testimony in a paper copy of a will.
Senator Westrom?
Thank you, Madam Chair, and thank you for that clarification. When you talk about the Adobe or a DocuSign, I mean, the current electronic process allows, in most cases, is not somebody's actual signature that they're moving with their hand. Just so we're understanding correctly, they can also push, most of the time it seems you push a button that says, select this as my electronic signature. Is that kind of what we're still talking here? So it's actually not a handwritten on the computer tracing the attempts of a signature, but just an imprint of a design or a picture of what somebody has picked as their signature. That's what we're talking about as an option here also, right?
Senator Westlin?
Madam Chair, Senator Westrom, in the definitional section, lines 1.19 to 1.21, it describes an electronic signature as meaning an electronic symbol, signature mark, or a process attached to or logically associated with a record and executed or adopted by a person with the intent to sign the record.
Senator Westrom?
And so we're expanding that to the non-testamentary documents here. Initially, I thought I read that we were opening it up to the will, but I appreciate your correction. I guess to the testifiers, I mean, I think it probably is a sign of the times we're in, and it does make sense in a lot of cases. The question I have just regarding expanding it is what have we seen for fraud challenges or anything in the few years we've had this, if we have? It seems that this probably does just make it a little bit easier to get mom or grandma or uncle, aunt, and walk them through just push the button here, just push this, just push that, and all of a sudden, these documents are signed. I guess, talk through that a little bit. Have we seen an increase in the past few years or not? These are oftentimes tough situations. When is somebody have a capacity issue or not? Early onset dementia or Alzheimer's, most of the time it's not that recognizable. Yet family knows that somebody's having, memory issues because they know this. Can you talk just a little more about that? Have we seen any upticks in fraudulent challenges or claims? And are we opening it up to an easier path of manipulating these documents, which I've handled some cases where it seems like there's enough family friction between brothers and sisters, or brothers and brothers, sisters and sisters, that one sometimes is the dominant sibling, maybe lives closest to the parents, and others from farther away call and wonder what's going on, and that's kind of the background of just trying to figure out as we walk through this this expansion. Can you talk about that, Senator Westlin, or your testifiers, please?
Ms. Lowe.
Thank you, Madam Chair. Senator Westrom, we have, I say we, the royal we, but we have many, many laws on the books that have changed or allowed for electronic signatures. It goes very far back in time. The definition that is included there comes out of the Uniform Commercial Code. So we have been doing electronic signatures for commercial documents, personal documents, contracts for a long time. We now have electronic wills that can be signed with an electronic signature. Mr. Cameron alluded to the fact when we did that notarial act, which is also a uniform law product that we brought to this commission, this committee, we had the same questions when we brought that act forward about the ability to commit fraud in someone else's name. You got to try pretty hard to fraudulently get mom to sign something. It may be easier to have mom sign in person when you move her hand than it is to get her an email, get her to do all that stuff to actually physically sign a document electronically. So I think the concerns about, and I'm not dismissing them, but the concerns about fraud have been there since we went down this path with commercial transactions and sales of homes and sales of buildings and all this other, and notarial documents that have to be notarized. So the safeguards are in place in the act and all of the acts that include electronic signature to make sure, as best as we can, that the signor has met the definition of signing, which is an intent to be signed, intent to be bound, and that there's video, there's all these different things to do. There's no law that we can draft that will get ahead of a bad actor. If someone wants to, grab mom's email and cause the signature, that is the same as a person who drives mom to the lawyer and says, Mom, sign this document right in front of the lawyer. So that's what these acts are meant to do. They're meant to facilitate the ability to allow someone to sign in a way that's easier than physical presence. But the fraud, we have seen no uptick any more than we would have seen before when it came to the ability to sign electronically. We already have, as Mr. Cameron alluded to, a problem with the ability to change beneficiaries on IRAs. I can go in and get my dad's password to his IRA and change myself, take my sister out as a beneficiary and put myself in. So we already have that happening. This is not going to change or make that easier or harder. It's no different than what's already happening, but it does facilitate the ability for people who cannot physically get someplace to sign, which is really what this is meant to do.
Mr. Kelly, I believe, wanted to add.
Yeah, go ahead.
Thank you, because it is a good question. And one of the things that I didn't say in my initial response that is that the act does require, anytime there needs to be either witnessing or a notarization, that you be in communication in a way where there's visual and audio contact that's simultaneous. And so if you have witnesses, they're watching this happen. Now, of course, could there be someone behind the camera or something like that? There could be. And the other thing that I would add is I haven't seen an uptick to specifically address your question. The Electronic Transactions Act, I can't tell you the date that it was adopted, but I think it was something like 2008.
I think so.
And that would allow me to sign a beneficiary designation for my parents. Like if I were able to find their password, I could log on at a computer at their home, and there's probably no way for, whatever financial institution to tell whether that's me or someone else. That's existing, that's there. This at least has those signature requirements where you're having witnessing or you're having a notarization in most of these documents, healthcare directives, power of attorney, and you'll be able to have that visual contact with the person who's witnessing or notarizing it. And so it's definitely a step better than some of the contractual things you can do under the Electronic Transactions Act.
Thank you. Does that answer your question, Senator Westrom?
It spurred another one. But, Madam Chair, I think this is it. So in that case, DocuSign doesn't always require like a recording or a visual. Are you saying that this will be tougher than a DocuSign situation? When you referenced a visual or kind of an audio recording, you're saying that has to be part of the record then? Or if somebody gets a healthcare directive with a DocuSign notice, from what you said earlier, my understanding is that DocuSign process, which is fairly common in the real estate, transactions, would be a similar way that these could be executed. Parse out the difference, and then coupled with this question, can you sign from any state, and can you sign from Canada or Mexico if you were on vacation there and executing documents? What is that all kosher and allowed?
Mr. Kelly?
Yes, thank you, Madam Chair. The question of can you sign in another state, yes.
Yeah.
The document specifically uses the same language that the Electronic Wills Act uses, and it says that you have to be in a state. But being in a state would prohibit you from signing it from Canada or Mexico, so state of the United States. And then as far as whether those signature requirements are present in every document that you would sign, no, I am sure that there are documents that don't require those signatures. What that goes back to is it depends on the document. So if I am signing a healthcare directive or a power of attorney, they both have in their own separate statute a requirement that exceeds me just signing the document, which I could do through DocuSign without someone witnessing it. With the power of attorney, it's notarized. So then you have a visual and audio contact with a notary who is observing and applying their notary stamp. And with a healthcare directive, it could either be witnessed or notarized. So you either have two witnesses who are remote or present, they could be there as well, that are witnessing the document being executed, or you have a situation where there's a notary on that document, and again, if it's an electronic notary, there has to be visual and audio communication in order to apply the notary stamp. Thank you.
Any other questions? All right. I believe you have a motion to send this to the Senate floor, Senator Westlin. So Senator Westlin moves Senate File 3602 be recommended to pass and re-refer to the Senate floor. All those in favor say aye.
Aye.
Any opposed? Motion prevails. Senate File 3602 is on its way to the Senate floor. And which bill were we taking up next, Senator Westlin?
Pardon me? We are going with Senate File 3606, the
Okay.
Administrative Hearings Provision Modification. I think we'll just go in the order on the agenda,
Great.
Madam Chair.
Whenever you're ready.
Okay. Sure I have the right thing up here. Thank you, Madam Chair. Senate File 3606 is related to the conduct of hearings, and I do have Commissioner Lucero here and Mr. Bauer as well, who will be probably the point people on the next three bills. This actually makes some minor technical changes around administrative hearings, and with that, I will kick it over to Commissioner Lucero.
Commissioner Lucero.
Good morning. Thank you, Chair Radom. Afternoon in committee. So this first bill, 3606, is a technical bill, and it does three important things. First, it aligns the language to better reflect the Court of Administration hearing processes. So they call themselves the Court of Administrative Hearings, and so it reflects that change. It further clarifies that the process the Department of Human Rights would use to initiate a contested case with the Court of Administrative Hearings, which is to submit over to them within 30 days after receiving that request. It also removes the requirements that the hearing should occur within the county where the alleged unfair discrimination practice occurred. That's on lines 113 to 115. There are many different ways that these hearings are held now, not necessarily in that specific county, and so we're removing that requirement from there. Thank you very much.
Are there any questions? Senator Kroon?
Thank you, Madam Chair. Out of the three things that this bill does, the primary things, I think the first two are good. My question is on the third thing about the location of the hearing. And I know that on line 116, it references section 14.57 through 1462, and I'm going through those right now, but is there any requirement in those sections that would speak to where the hearing should take place? Or maybe that could be for council too, I guess, whoever wants to answer it.
Commissioner Lucero?
Thank you, Chair. Senator Kroon, thank you so much for your question. So this actually is something that the Court of Administrative Hearings approved. They actually have their own processes that are detailed there about how and when hearings are heard based on the type of hearing and where it makes sense to do so. So this is really just deferring to their processes that they do with all other cases instead of requiring a specific process.
Madam Chair.
Senator Kroon?
Thank you, Madam Chair. So they may have their own process set up. My question is that process in statute?
Council's taking a look at the statute and can respond to that. Ms. Primo?
Madam Chair and members, Section 14.58 doesn't seem to specify the exact process. It states that the notice shall state the time and place and issues involved. So I'm assuming that it's left to the Court of Administrative Hearings to sort of discuss and with the parties and figure out a location, and I don't know what that process would be.
Madam Chair.
Senator Kroon?
Thank you, Madam Chair, and thank you, Ms. Primo. Yeah, and I was looking at that same statute, and I couldn't find anything in there. I guess my concern is that if we have a business that's located in Roseau, would they have to come down to St. Paul for this hearing? Could that be possible if your bill were to pass?
Commissioner Lucero?
Yeah, thank you. Senator Kroon, one thing that might be helpful is that this is incredibly, incredibly rare. In the 7 years that I've been in this position, 0 cases have gone forward. So this is not a typical situation. The way that you would even get here, there would be a fully investigated case that our agency would investigate, would issue a determination, and then the party would have an opportunity to appeal that. That appeal would go through. Then and only then would there be a possibility for them to move it forward to the the Court of Hearings here, the Court of Administrative Hearings, and the department would decide whether or not they would recommend it moved forward. So we don't anticipate a lot of this happening at any point. What I can tell you is that anyone maintains their rights to bring a case to court, to district court right now. And similarly, there can be, depending on where that's filed, may require an employer to go to wherever that district court is. But this isn't something that you're going to see very often, if ever. I think in the last 10, 15 years, we could only find one time where a case went to the Court of Administrative Hearings, and that was in fact why the OLA suggested we make these changes to tighten and clean up this process and make it clear to people when that does happen.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. And I understand that courts have their own rules on venue if it were to get to the stage of the lawsuit, but, and maybe this isn't something that happens that often, but the legislature put this in here for a reason at the time, and I'm trying to think of a reason why we should take it out, and I'm struggling to find one. I get on 1.14, if your office, the commissioner, wants to kind of not have to make the designation where it should take place and wants to kick it over to the Court of Administrative Hearings, I think that makes some sense. But I also think that you could leave in the language about within the county where the unfair discriminatory practice occurred or where the respondent resides or has a principal place of business as some sort of assurance for those outstate companies that they wouldn't have to come all the way down to St. Paul if they wanted to exercise their right to this hearing. And maybe the Court of Administrative Hearings already has policies like that in place. I would even like to see it in statute where they could provide for a virtual meeting if elected by the business. But it seems like I would prefer to see that comfort language for those outstate businesses remain in statute.
One thing I did just want to add, Senator Kroon, is I know there's 2 locations. There is a St. Paul location and a Duluth location for the Court of Administrative Hearings. Did you have anything you wanted to add? Commissioner Lucero?
Chairman Verbatim, thank you. So they also do quite a bit of their work via Zoom. And so there is different ways that they are working right now. And what I'd love to do is circle back with you if you're okay. I want to look at the rules that they have in place because my guess this is detailed quite a bit through their rules process. I just can't look at those very quickly, but I'll circle back with you and confirm how that process works.
Madam Chair.
Senator Kroon?
What is the path for this bill today?
The path was to send this to the Senate floor.
Madam Chair and Senator Kroon.
I'll go to Senator Westlin and then back to you.
Senator Kroon, if we decide between here and there that we need to do something to clean it up, I will be more than happy to do an amendment.
Madam Chair.
Senator Kroon?
Thank you, Madam Chair. So you're saying you're willing to work and possibly do a floor amendment to deal with this issue? Is that your preference?
Senator Westlin?
Madam Chair and Senator, if we determine that the rules for the Court of Administrative Hearings, that's a mouthful, is not clear about that, we can have some further conversations and we could do a floor amendment.
Senator Westrom?
Madam Chair and Senator Westlin, would you be okay with leaving the county language in for now? Because I concur with Senator Kroon's comments. I guess I would think there shouldn't be an issue with that, but if there's a reason that we have to pull it out, I would rather that be the path on the floor than having to put it back in. It's always tougher. Would that be an acceptable path for you?
Madam Chair and Senator, it's
Senator
my
Westlin.
understanding that the Court of Administrative Hearings actually was asking for that language to be removed. And so based on that request, and this is a bill having to do with their process, I would probably defer to that at this moment. It is my understanding that a lot of the hearings these days, even in district court, are happening by Zoom. And if that is built into their rules, then it seems to me that that would be the most convenient way for these hearings to take place. But like I said, I'm willing to continue to have a conversation, and if there's a need to make a change or a tune-up, I'm happy to do that.
Senator Westrom.
Madam Chair, then I would suggest we just lay this over in the committee, and maybe we can have those discussions, and if it gets resolved, it's quick and easy to kick it out. But I don't think they've made their rounds to most of the committee members to justify this, and Duluth and St. Paul are all within about 30 minutes of the Wisconsin border. Ortonville, Minnesota, on the other end is part of my district, borders South Dakota. Roseau gets to be quite a long ways for those businesses. So, I would hope we could maybe hold it over and kind of work this through. I think Senator Kroon has raised a pretty valid point.
Madam Chair, I guess
Senator
I would,
Westlin.
At this point, we do have short deadlines in this session. I'd like to keep the bill moving, so I don't know that I would agree to laying it over. But I know Ms. Primo's looking at things, and I know the commissioner's looking at things, maybe having nothing to do with this.
No, I was just talking with Ms. Primo. Just got a few additional pieces
Okay.
to add, so
Thank
I'll go
you.
to Ms. Primo first.
Madam Chair and members, this is a quick look at the rules, which are extensive. So, but one of the provisions in the rules permits the administrative law judge to change the location of the hearing based upon the request of a party where necessary to provide a fair hearing. So there's at least some mechanism available to take into account the parties' locations. There are some other provisions, and what I'm not clear on is whether this applies in the rulemaking process versus the contested case hearing process, but to take into account the location of known parties, witnesses, and other participants so as to maximize convenience and minimize costs. So that appears in a couple different spots in the rules.
Senator Kroon.
Thank you, Madam Chair, and thank you, Ms. Primo. I'm willing to work with the bill author, I guess high level, and I appreciate that. It sounds like there is a mechanism for the respondent to request a change in the hearing location. I guess high level for me, I just want to make sure, I guess really what I'm getting at is that this change is not being done for the benefit of the convenience of the Court of Administrative Hearing or the Commissioner's office. I would like to see the convenience for the respondent, the business owner that is outstate. And so if that's already built into the court rules, that's one thing, and I'm willing to work on that. But if it's not, it seems like we should leave some component in statute to provide that assurance to the outstate businesses.
I'm sorry, I wasn't clear, Madam Chair, if that was a question or a statement. I'm sorry.
Okay, are there any other questions? Senator Limmer.
I'm trying to follow along here with the discussion. So are we at a point where we're going to continue working on this bill after it leaves the committee? Is that the proposal that's before us, or the understanding?
Madam Chair.
Senator Westlin.
Senator Limmer, I am generally always open to continue working on things. Again, this is actually a fairly technical bill, and as the Commissioner indicated, these are situations that rarely arise because this is a situation that comes actually at the very end after an appeal has already happened. And so we can do a deeper dive into the rules to make sure that this is, that the venue actually is reasonable and fair for both parties, which would include not only the employer, but also the alleged aggrieved party, witnesses, and so on. And I think what I understood Ms. Primo to say is that the rules for the Office of Administration, Court of Administrative Hearings, that they have extended rules, as the district court does, about how process works. And so I just want to make sure we aren't correcting a problem that isn't a problem.
So, Madam Chair,
Senator Limmer.
going back to the question I asked, are we working under an understanding that this is going to get patched up outside of a policy committee?
I'm sorry, Madam Chair.
Senator Westlin.
Could you repeat that?
Senator Limmer.
I'm trying to get an answer to my question.
I'm trying to understand your question.
And the question is will this discussion continue with the understanding that the policy might be refined outside of a policy committee? Is that what we're planning on doing?
So I'm just going to add one thing before I go to you, Senator Westlin, on kind of your preferred path. But the rules that are set out by the Court of Administrative Hearings are under the jurisdiction of the State and Local Government Committee. And I think Senator Westlin wants to get some clarification on those rules and how that would, how they would determine the venue, the pieces that Ms. Primo spoke to, where there is some mechanism to take into consideration where the employer and where the aggrieved party lives.
So, Madam Chair,
Senator Limmer,
I thought
then I'll
the
go to Senator
motion would
Westlin.
have been to move this bill to the floor.
Yes, that was what the motion would be.
But didn't you just say that it should go to a different committee? for a
No,
better
I was,
understanding?
Senator Limmer, I was saying that the rules that are set out for, already in statute for the Court of Administrative Hearings, if there were changes to the existing rules, that would be under the State and Local Government Committee.
So why wouldn't it go to that committee, Madam
Because,
Chair?
Well,
Madam
we're not
Chair?
changing the rules.
Oh. But there was a discussion alluding to a continued discussion between Senator Cruen and the chief author to finish the bill, or at least finish a discussion. I guess the point that I'm trying to make is that the Judiciary Committee is usually the last stop before a bill goes to the floor. And our work should be done here, not in a private discussion somewhere else. And so if that's what we're going to be deciding in the next vote, why are we not finishing our work here? And if it means it takes a little more time, we lay it on the table, we have that discussion, we have another presentation to the committee, and then we vote. And it's all out in the public eye. I think that's been the tradition of the Judiciary Committee, and I hope it doesn't stop today.
Madam
Okay,
Chair.
I'm going to go to Senator Westlin just to see what her preferred path would be.
Madam Chair and Senator Limmer, this is a bill that amends the administrative hearings provision that has been brought with the approval and request of the Court of Administrative Hearings. We don't believe there's anything that needs to be changed in the bill, which is why I'm suggesting it be moved to the floor. My understanding of Senator Cruen's questions, what he had some questions that can probably be answered by referring to the rules of administrative hearings that would not necessarily require a change in this bill. So I think this is being overly complicated. It's a technical correction bill, and the language regarding the administrative hearings is language that the Court of Administrative Hearings has approved. It's their jurisdiction. It's their process. So again, I think that this has become somewhat overly complicated, and my motion stands that it be passed to the floor.
Okay. Senator Cruen.
Thank you, Madam Chair. Maybe we can just clear this up. Is there anybody here from the Court of Administrative Hearings by chance?
No. Okay. So we've got the motion before us. Senator Westrom.
Madam Chair, is there anybody else here that wants to testify for or against this bill? And then I have a proposed amendment.
Can begin by stating your name and title for the record.
Hello, I am Dr. Roger Day, and I may be one of the people in this rare situation. I have brought a complaint to the Human Rights Department and had it decided adversely, appealed the decision, and had the appeal issued, which was very contestable. And so I believe that I am in this situation where I do have a commissioner's decision to be appealed. And so I think the situation bears on my particular circumstance. I'm not as concerned about the venue question as the change in lines 1.11 and 1.2 that goes from shall forward to shall decide whether to forward. That turns the whole thing on its head and says the commissioner can actually block this request. So that's a really, really important edit to this language. And you know, I just came across this now, and so I haven't thought it through deeply, but it looks to me like that is a really, really serious change and shouldn't happen. So I would argue vehemently against this language that says decide within 30 days whether to or not.
Commissioner Lucero.
Chairman Verbatim, thank you so much. I want to make clear here that everyone retains 100% of their rights to go to district court at any time. What we're talking about here is the exhaustion of administrative remedies and the path forward from there. And so there's no foreclosing on any right that somebody has to go to district court if they so decide to do so. The administrative path is sufficiently completed.
All right. Sorry, Senator Westrom, did you have follow-up?
Madam Chair, just a question to the testifier. Whereabout is your location or business? Where do you live?
So I'm in Anoka County.
Okay, so not in a rural setting, hence the question. But
right, I'm in Senator Kroon's district.
Okay, Madam Chair.
Senator Westrom.
The language that is being struck, and I'll ask counsel if she could help make an amendment, but basically I would propose that we keep the language that allows the administrative hearing to be set in the county of the respondent. That's being deleted. I would like to move to keep that language. It's not telling me on my computer what line that is, but I think that within the county where the
And I can go to Ms. Primo to read what the amendment would be, Senator Westrom.
Okay. Lines 114 and 115. So, Priya, if you could
Ms.
give me
Primo?
enough guidance of what I would like to keep, I would move to keep the language from being stricken on 114 and 115.
Madam Chair and members, I think the amendment would be page 1, lines 13 to 15, reinstate the stricken language, so that entire sentence would be reinstated.
Okay.
Unless there's any additional changes to make to the underlying statutory language.
Senator Westrom.
Madam Chair, and I would hope we could, if we're going to move this out, we could keep this language. Sounds like there's some discussions that would continue to happen. I would feel much better to have this language in rather than to have to try to get to the floor and then put it back in. If there's agreement, it's much easier to have the language in and then modify it accordingly. I think back to five plus years ago, a situation out in Wheaton in my former part of my district. That's 30 minutes from the South Dakota border. Having a situation in a business in that community. Senator Kroon's talked about Roseau as an example. That is a long ways from here. I just think this language brings much more fairness to keeping it wherever the respondent is in the county they operate. And to have to ask for a judge to give them that when they're already trying to fight for their position or respond to their position, I just think is an unfair position to put the responding party in the legal counsel. And if there's things you got to give on, you certainly would probably give on jurisdiction and venue if your respondent, even if it means you have to drive 4 or 6 hours one way to get to the cities. And I just think this is a language that at least keeps fairness, geography fairness in place, and I would just move that amendment.
Okay, Senator Westrom, I'm going to have Ms. Primo read the amendment correctly one more time, and then I'm going to go to Senator Westlin for her thoughts on the amendment. Okay, Ms. Primo.
Can you get just a little closer? I can hear you, but it's just a little difficult to hear you.
Okay, we're going to go to Ms. Primo to reread the amendment so that it's correct, and then I'll go to Senator Westlin. Ms. Primo.
Madam Chair and members, I misunderstood the intent, so I will read the amendment, which I believe it would be page 1, line 13, reinstate the stricken language. Page 1, line 14, reinstate everything after the comma. Page 1, line 15, reinstate the stricken language. With that change, it would leave the designation by the commissioner out and instead read that the hearing shall be conducted at a place within the county where the unfair discriminatory practice occurred or where the respondent resides or has a principal place of business.
Senator Westlin.
Madam Chair, I'm a no on the amendment.
All right, Senator Westrom moves the amendment as described by council. All those in favor say aye.
Aye.
Opposed? No.
Madam Chair. I move for reconsideration of the motion.
I think I'm gonna,
Too many conversations going.
Yeah, we'll do division, do hands. So again, all those in favor of the
Madam Chair,
amendment.
point of order. Can you at least announce the vote first, and then
It was a voice
that's
vote.
proper to call division after a vote has been closed? I think we
okay.
heard well which one the vote. The ayes do have it, but go ahead and announce it, then we can call the division.
It was
Just to follow
unclear to me, so I would like to ask for division. All those in favor, please raise your hand. Okay, and those opposed? So the amendment is not adopted.
Can I ask for the count of the vote?
Yes, 5-4.
Okay.
Against.
So Senator Westlin moves that Senate File 3606 be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed?
No.
Okay, the motion prevails and Senate File 3606 is sent to the Senate floor. We'll go to Senate File 3607. Senator Westlin.
Madam Chair, we have another bill. Let me just grab it here. All right, Madam Chair, this is another bill, Senate File 3607, primarily, again, what I would characterize as mostly technical in nature. Section 1 provides that employers would post printed materials outlining an individual's rights under the MHRA and so forth. Section 2 provides the same notice for students. And I would defer for further comment from the Commissioner Lucero.
Commissioner Lucero.
Thank you, Chair. The only thing that I'll add at this point is that MDHR is working on an amendment that will be ready for labor on Thursday when we move the bill there that clarifies that MDHR produces these materials, produces all of the language, and it'll be available in 5 different languages. So it what mirrors what exists elsewhere. So these are. So I just wanted to clarify that will be changed as well. If there's any concerns that this is putting a burden on employers or schools, wanted to clarify, it is not. We are going to do all the work. Thank you very much.
Any questions?
Thank you, Madam Chair. Commissioner, there's a cost for printing. Is there a cost that your agency has defined for this printing business?
We're actually,
Commissioner Lucero.
Chair, apologies. Senator Limmer, thank you very much. This will be offered digitally, and so there will be no costs, but it'll be up there in 5 different languages for anyone who wants it or needs it. We imagine some people, especially schools, will put it on their website.
Madam Chair,
Senator Limmer.
we're imposing a responsibility by employers in lines 1.8. Each employer must post and maintain printed materials. So is this a cost to employers and not to the agency? And do we have an estimate of what that cost would be to employers in aggregate?
Commissioner Lucero.
Chair, verbatim, Senator Limmer, thank you so much for that question. So it might be helpful to just clarify that employers have existing obligations to provide employees with information around Minnesota paid leave, as well as many federal requirements. And many employers actually just work with places that actually just deliver all of them for them, and then they put them up on in their business. We certainly do that as well. And so any cost will be negligible. The cost of printing a piece of paper, which I believe runs about 3 cents right now, to put it up in your where you post those in the business.
All right.
Okay, we're going to go to Senator Westrom, then Senator Holmstrom, then Senator Kroon. Senator Westrom.
Madam Chair, to the Commissioner, did you say there was an amendment added last Thursday in Labor Committee, and we should you're highlighting that, or is there an amendment coming forward this Thursday for Labor Committee?
Senator Westrom, the path for this bill is to go to the Senate Labor Committee after our committee. So there is a bill that would be, there's an amendment that's being worked on when the bill is heard in labor. That's correct, Commissioner Lucero? Yeah, yes, that's correct. Senator Westrom?
Well, Madam Chair, that would raise concerns again. So now you're telling us there's an amendment that's coming later this week, but we're not going to review that here at all, and you already know there's changes coming. Why wouldn't we have the amendment here, Commissioner?
Madam Chair,
Senator
I'll
Westlin.
respond briefly and then let the Commissioner respond, but I believe the amendment actually is not related to items specifically under the jurisdiction of this committee.
Madam Chair, I'm sorry, I'm having trouble hearing Ms. Westlin. You're tailing off. If
Sorry
you could get a
about
little
that.
closer to your microphone, please.
Yep, it's also easier to hear when people aren't talking. But anyway, I believe the amendment that's going to be brought in the Labor Committee is related to the Labor Committee's jurisdiction, but I will have the Commissioner add anything to that she would like.
Commissioner Lucero?
Thank you. Senator Westrom, it does not change any of the substance of the bill. It just clarifies that it just directs the agency to develop and distribute it.
And Madam
Senator Westrom.
Chair, Commissioner, Would that have any consequence if somebody doesn't comply and they're going to now have a penalty imposed to them? Or is there no penalty if they don't comply?
Commissioner Lucero.
Chair, thank you. Senator Westrom, great question. There is no penalty.
And Madam Chair.
Senator Westrom.
Commissioner, we're supposed to just trust you that that's the case without having the language in front of us.
Commissioner Lucero.
Thank you, Chair. Senator Westrom, it's actually the statute that details how and when remedies can be put in place, and there's no remedy that is in the statute that allows for any penalty for this. And so I would ask you to refer to the statute around when remedies can be applied, and there's not here.
And Madam Chair, or Commissioner, is there a reason you don't have the amendment ready today so the bill could be put in the order that you're already telling us it's going to be changed into?
Commissioner Lucero.
Thank you. Senator Westrom, thank you. So we've been working to get feedback from different stakeholders, and this was a question. It was always our intention to make sure that the agency produce and distribute to make it really easy for employers and schools to get this information out. And so this has been feedback that we've been getting over the last couple of days. Not a problem. We've been working before it gets to labor to get that in place. We appreciate the feedback from folks.
So I did have Senator Holmstrom, and then I'll go to Senator Kroon.
I'm done for now, Madam Chair.
Thank you. Would you? Okay, Senator Kroon.
Thank you, Madam Chair. And then I just wanted to follow up on Senator Westrom's point, ask council, is this entire bill within our jurisdiction?
Ms. Primo.
Madam Chair and members, because it is within the human rights chapter, it is within our jurisdiction.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. Okay, so we know there's going to be an amendment. The entire bill is in our jurisdiction. It seems to me that this committee should do the work on the amendment, but before, I'll let Senator Holmstrom jump in here. I didn't mean to interject, but could you re-explain the amendment that you were planning on bringing in the Labor Committee? Could you explain that again?
Okay. Commissioner Lucero.
Thank you, Chair. Thank you, Senator Kroon. So the amendment just directs the Department of Human Rights to produce and develop that, and to do so in 5 different languages.
And Madam Chair, just to
Senator Westlin.
clarify also, the bill is going to Labor because the Labor Committee also does have jurisdiction over this bill.
Yes, my understanding is it also would go to one of the education committees as well after the Labor Committee. Senator Holmstrom.
Thank you, Madam Chair. So that I really do wish we had that language today, because my first question is, do we have the signs? Do we know what you want them to say, and what exactly that language would say?
Madam Chair, members,
Mr. Bauer.
gladly read the amendment that we are currently working on to be introduced in Labor Committee on Thursday. I don't know that it addresses the entirety of your question, Senator Holmstrom, but I'll just share with you, this would replace the first sentence of the language. Excuse me, I don't have line numbers in front of me. The Commissioner shall consult with the Commissioner of Labor and Industry to create and distribute an educational poster providing notice of employee rights provided under this chapter. The notice shall be available in English and 5 of the most common language spoken in Minnesota. And then there is an additional replacement of the lines the line that begins, these materials must be maintained. That sentence would be replaced with, each employer must post and keep posted notice of individuals' rights created pursuant to the subdivision in a place where employees' notices are customarily located within the workplace. So trying to communicate that they should be maintained in the same way that other employee notices are posted in the workplace.
Senator Holmstrom.
Thank you, Madam Chair. Senator Westlin, what type of entity does not have to post these signs?
What type of entity? Could you repeat that?
What type
Senator
of entity
Holmstrom.
would not have to post these signs?
Commissioner
Chair,
Lucero?
I'm trying to understand the question. I guess I will answer it in the opposite way, which is employers and schools will need to post.
Sure.
And so that is the universe there.
Senator Holmstrom?
Would an all-girls or all-boys school be required to post these?
Sorry, Commissioner Lucero.
Chair. Thank you. So it would require that all schools that are subject to the Minnesota Human Rights Act have to post this. It's already something that they're posting. They usually post them in their handbooks or on their website, and it's just under the existing obligations for the Minnesota Human Rights Act.
Senator Holmstrom?
Would a religious organization be required to post these as an employer?
Commissioner Lucero?
Yeah, thank you very much. I'm just wanting to make sure to say that all employers have to follow the Minnesota Human Rights Act, and where there are exemptions in the Minnesota Human Rights Act, that is detailed in the Minnesota Human Rights Act. So if you're looking for like a specific type of school, if they're an employer, they are subject to the Minnesota Human Rights Act, and they may also have exemptions in place as well.
Senator Holmstrom?
So if a religious employer is exempted by the Human Rights Act, are they still required to post this language?
Commissioner Lucero?
All schools are subject to the Minnesota Human Rights Act. There may be provisions that they're exempted from. And it sounds like there's something specific that you're getting at, and I'm wondering if you could help name that a little bit more clearly so I can answer your question.
Senator Holmstrom?
Sure. So specifically, if a school, a religious school that has exemptions for pieces of the Human Rights Act, are they still required to post this? My concern is, so in here, in the language, you have encouraged to provide information in plain language. And this encouraged confuses me because there's certain parts of this are required, right? We're requiring them and then they're encouraged to. And my concern is potential litigation that might come as a result of unclear language.
Commissioner Lucero?
Yeah, thank you. Chair, and move verbatim. Thank you so much for your question, Senator. So we're providing the materials, and and then also there's no litigation for failing to provide this information. There's no penalty for failing to provide this information. It really is about proactively making sure people are aware of what the laws are so that they're not in the dark about what the laws are. This is completely common. It happens in every single workplace that we're in right now. It's just that there's no process at this place for putting up Minnesota Human Rights Act policies next to all of the other federal and state policies you put up. And so no concern for litigation because there's no penalty at all.
Thank you.
Okay. Senator Kroon?
Thank you, Madam Chair. I also am confused by the encouraged language that's in this bill. And the way it's drafted, now there may be some amendment coming in the future that I haven't seen, that I've heard, but I can't keep an amendment that's not in front of our committee in my head that may or may not be offered at a future committee stop and may or may not pass that future committee. So I think we have to work from the bill that's in front of us right now. It would be very helpful to have this amendment, but I'm going to work with the bill that's in front of us since there is no amendment that's before us. And it says businesses are encouraged to provide information in plain language using adult learning principles on how both employers and employees are stronger when civil rights laws are followed. If I'm a small business owner, I have no earthly idea what that means. And I don't know what I'm supposed to do in that situation. And I know it says encouraged rather than required. Although encouraged or required is a hop, skip, and a jump away from encourage, and I have concern about that. But what exactly is a business supposed to do with this language?
Commissioner Lucero.
Thank you, Chair. Thank you, Senator Kroon. So we recognize that businesses communicate a variety of different ways based on what's right, and schools are based on what's right for that business. And so you can imagine some businesses are very, very big, and they have like a portal where they put information up on. Other businesses are going to be really small. Maybe they have a huddle at the beginning of the day, and you're talking through different options. And so what we don't want to do is require something that doesn't take into account the fact that there are a lot of different businesses that manage in a lot of different ways. And so what we want you to do is to provide the information in as plain language as possible, in a way that people learn and understand, in a way that is right for you and your business. And so that is what we mean by, what we want to provide that flexibility to all the diverse businesses that exist in Minnesota.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. You said there's no penalty if the businesses choose to not follow this encouragement. But what about the actual, I just want to be clear, what about the actual posting requirements? Is there a penalty if a business doesn't do that part of the bill?
Commissioner Lucero.
Chair, and verbatim, Senator, there's no penalty provision built into any part of the statute at all, nor would be allowed for under the Minnesota Human Rights Act. What I can say, broadly speaking, though, is that where we see businesses get in some trouble is where they don't have policies, they don't share those policies, or they have the policies, but they don't train on them, they don't follow them, they undermine them in different ways. And so failing to have policies, failing to communicate those policies, failing to train on those policies can be part of an analysis that goes into a bigger case around discrimination. And we're always encouraging employers to proactively have solid policies in place that they've communicated and trained on to prevent discrimination from happening in the first place. That's better for businesses holistically, and it's better for employees to prevent problems on the front end.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. And getting to these requirements and these encouragements that are in this bill is, in terms of a complaint that the Department of Human Rights gets, are you saying that if an employer has not done these things, that you're not going to use that against them in the procedure?
Commissioner Lucero.
Thank you. Thank you for your question. And so on its own, there's no case that would be allowed to be moved forward under statute for just that. But right now, employers are required to have policies in place. This is just an opportunity for you to put that policy up, clearly articulated where it should be with everyone else. So on its own, it's not a charge of discrimination. There's no prima facie of discrimination. No one can move such a charge. It can be part of an entire package of where employers don't have policies, are not communicating those policies, are not training on those policies, are not enforcing those policies. So you're carrying many, many, many factors that can go, that employers find themselves where they are liable. Good employers have good policies, post those policies, train on them, hold people accountable, and they avoid liability.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. Thank you. And so on its own, okay, I understand that, but as you kind of said, what we're doing here is we're setting up some encouragements for employers to do certain things, but the problem is that what is in this bill is hard to understand for the average employer, especially small business owner. And so they may not do it. And then my concern is this language that we're enacting into statute, if this were to pass, will be used against the employer either in an administrative proceeding or in litigation. And so that's my concern here, because I don't know what this means. Adult learning principles. Like, these are not things that the average small business owner is going to really understand, so they probably won't do it. So do you anticipate that the failure to do this by employers could be used against them in future administrative proceedings or litigation?
Commissioner Lucero.
Chairwoman verbatim, Senator Kroon, what I anticipate is that MDHR will produce and send to a business a poster that details what is the law in Minnesota. It will be in plain language. It will explain things in ways that are easier for adults to understand, and it will be posted by the employer. So we're making it very easy to post along with everything else. So DLI also requires such posters. They're up everywhere. You see them. They provide them for free. It'll just be posted right next to them. You have therefore met the terms of this, and on its own, it cannot be held against anyone.
And
Madam Chair.
Madam Chair, actually, could I just?
Senator
say something
Westlin?
Quickly. I mean, I do want to bring us back to sort of the nugget here. It's a bill about notice. So the requirements of the Minnesota Department of Human Rights exists. We aren't creating anything new. We're simply providing the opportunity for people to be informed of those rights and the obligations under the Minnesota Department of Human Rights. It is a bill about notice. And the Department of Human Rights is making it as easy as possible by preparing the materials and providing the materials. And in the end, what the commissioner is saying is this actually helps employers be more proactive to make sure that the information is available to their employees, but also that they are being a little bit more thoughtful regarding policies and procedures and so forth.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair. The problem with that analysis is that that's not the bill that's in front of us. And it may be the bill that eventually goes to the Senate floor, but it's not the bill in front of this committee. If this were clearly drafted so that there's going to be a piece of paper that's drafted by the Department of Human Rights, and it's just simply a posting requirement, that would be one conversation. But what's in this bill it isn't that bill. It puts all sorts of ambiguity, and the onus is on the employer to come up with what they're supposed to post. That's how I see it anyway. So if this were just a posting bill, then it's just another piece of paper that needs to be posted in the break room along with, the dozens of other ones, and it's death by 1,000 postings. And, then the argument is simply, we have so many of these things that nobody actually reads them or pays attention to them. But that's a much, simpler conversation to have. My bigger concern is that that's not the bill that's in front of us. So it seems to me that if that's the intent of this bill, is to just simply make it a posting requirement and everything's going to be done by the agency, then we should see that bill and we should see that amendment.
Madam Chair.
Senator Kroon, I think it'll be important for the Committee on Labor and the Committee on Education to inform this bill in this process, but we do have room to bring the bill back to this committee. So that might be the best path forward, is for this to go to Labor, to go to Education, and then to come back to Judiciary. Senator Westlin.
Sure.
Senator Kroon.
There's room to bring it back to the committee, but is that an assurance that it will come back to the committee?
It's really up to the chief author, Senator Westlin, but there's room for us to hear it in Judiciary.
Madam Chair, or it's up to Chair Latz. But this bill has to go to Labor. We've already had parts of the amendment that is being prepared that will be presented in Labor. It's going to go to Education Finance. And if Chair Latz, based on the request of this committee, would like to see the bill again, sure.
Yep, and I know that Senator Latz is, if an author wants to hear it back, and the members want to hear this in committee again, I'm sure we'll make time for it. Committee administrator is ensuring me that there's time for us to hear this bill again. So I think the best path would be we send it to Senate Labor, Education Finance will hear the bill, and then it can come back to the Senate Judiciary Committee.
And Madam Chair, the great
Senator
news,
Westlin.
Senator Kroon, is you're on Education Finance, so you will get an opportunity, and so is Senator Holstrom. Oh, was it? Oh, policy. Oh, never mind.
It's education policy, so maybe not. I'll get to hear it in Senate Labor. Senator Westrom.
Well, Madam Chair, then I hope we have the motion to pass it out of here moved or changed to reflect that it would pass out without recommendation to return back to Judiciary after it's gone through the other committees. sounds to me that that's what we're talking about, but I don't think we should pass it out of here with recommendation then. And then we can add that when it comes back.
Well, my motion on
Sorry,
my
Senator
bill-
Westlin.
Madam Chair, my motion on my bill is that it be recommended to pass and be sent to labor. And people can vote on that however they want to.
Senator Holmstrom?
Well,
Thank you, Madam Chair.
Did you say Westrom or Holmstrom?
Oh, I said Holmstrom, but if you had
Okay, go
follow-up,
ahead.
you can go, Senator
Well,
Westrom.
Madam Chair, if I could just, to that point, we're being told one thing from the chair's saying the author of the bill gets to decide. That is opposite of the way precedent, custom, and usage is around this place, but maybe that's the new custom, that the authors get to decide if they bring a bill back. But if we're being told from you as a chair that it's going to come back, and the author I thought the author would then be open to that change, but it sounds like we're
The
hearing two
author is
different
open
things.
to it.
I
I was
said
making the
sure.
suggestion from here that we would have room to hear this after it was heard in labor and education policy. And Senator Westlin has agreed, so the path would be for this bill to go to Senate labor, it'll go to education policy, and then after education policy, it would come back to judiciary.
Then I think at the minimum, it would be apropos that the motion, whether Senator Westlin modifies her motion or somebody else does, you as chair,
You can
should
certainly
pass
bring
out without
forward,
recommendation if what we're being told is the path that we're looking at. That's my point.
well, you
I'll
can
let
certainly bring
Senator
forward a
Holmstrom
motion
talk.
if you'd like Senator Westrom, or, yes, Senator Westrom, but Senator Westlin will bringing forward her recommendation, her motion with recommendation. I'll go to Senator Holmstrom.
Thank you, Madam Chair. Commissioner Lucero, you had mentioned that the purpose of this bill is to help employers be more proactive and that it doesn't have penalties. My question is, if the bill has no teeth, is it really necessary to create a law? Couldn't your department just create these flyers and give them and provide them to businesses who want to be proactive and limit their exposure?
Commissioner Lucero.
Thank you, Chair. Thank you, Senator. So it is required of the Minnesota Human Act, in the Minnesota Human Rights Act, the public policy is, it states that the public policy of the state is to secure for persons in this state freedom from discrimination. It is, discrimination harms all of us. It harms businesses, it harms everyone. And so it is important that we proactively are providing tools to prevent discrimination on the front end. And that's why we are looking for opportunities to make sure people have the law in front of them.
Senator Holmstrom.
Is it your testimony that your department is not capable of doing that without passing this law?
Commissioner Lucero.
Thank you, Chair. No, that is not my testimony.
Senator Holmstrom.
So then what is the purpose of this law if it has no ability to be enforced and also isn't necessary by your own admission?
Madam Chair, it would be
Senator
really
Westlin.
great if the good senator would not put words in the commissioner's mouth, number one. And number two, this isn't a cross-examination, and there's not really any need to be hostile, and the conversation will be moved forward much, much better if a little modicum of respect were afforded to our commissioner.
Commissioner Lucero.
Chair Umar verbatim, thank you, Senator. The proposal and the purpose of this is to ensure that employers and schools inform workers and students about their rights under the Minnesota Human Rights Act.
Okay. We do have a motion from Senator Westlin. Senator Westrom.
Madam Chair, Commissioner, can you explain to us what adult learning principles are?
Commissioner Lucero.
Thank you. Thank you. So adult excuse me, thank you, Chair. Senator, thank you for the question. Adult learning principles are principles that allow that recognizes that adults learn a certain way. And so very often trainings occur where they're just reading the change to policy and they're not actually engaging with it in a way that they can learn. And so if you've gone through good policy trainings, you'll see they're interactive. They ask questions. They're making sure you understand it. You're building upon it. Those are adult learning principles right there, to make sure that somebody actually understands it. And when employees understand policies, they follow policies better.
And so,
Senator Westrom.
Madam Chair, Commissioner, where is this widespread understanding of what you just explained to us? What college class did I learn that in? Or what high school class do you learn that in? Or where do you get that information?
Commissioner Lucero.
Thank you, Chair. Senator, thank you for your question. And so just the way that adults learn, it might sound like a term of art, but it is just pretty standard in how people develop trainings to make sure that people are actually understanding the trainings.
So, Madam Chair.
Senator Westrom.
Commissioner, would this apply to farmers that employ one or two people on their farm?
Commissioner Lucero.
So it applies to, thank you, Chair. So it applies to all employers. And again, importantly, the material is coming right from the Minnesota Department of Human Rights. So we'll provide it in a way that is accessible, easy to understand, kind of utilizing adult learning principles across the board. And so, so I'm not expecting every employer to know how to do quality training. I do think it is in every employer's interest to understand how to train well on all of their policies. But I understand that it is something that we can help provide that information on.
So Madam.
Senator Westrom.
Madam Chair, Commissioner, this isn't helping this bill. My farmers like to farm. They need to take care of their livestock. Mm-hmm. And now we have one more piece as a small business owner that they have to figure out how to deal with. Maybe they don't want to come to your department to get this information. We can't figure out what that information would be as policy makers around the table. It's unclear to many of us, and now we're going to try to pass that and give you more statutory authority to make them do this. Once we put it into law, and then somebody hasn't done it, then the next step is now it's in statute. Now we need teeth. So that'll be the next thing you come along with. So then you can go after farmer with one or two employees one more time with a penalty, not just that they didn't post this, and figure out what this language meant. This is far, far, far from showtime ready. And it looks to me like there's more of an agenda under this, one more burden on our small business employers. And so I don't know what you did all fall and winter, but the fact that we're hearing this for the first time as most legislators currently, I don't think you've got this ready for prime time, and I think it should be laid over. Madam Chair, I would at least move to amend the motion to send it out without recommendation if it's going to pass out of this committee today. So I'd amend Senator Westlin's motion.
Okay, so we have a motion from Senator Westrom to amend Senator Westlin's motion. Did you want to speak to that,
Yes.
Senator Kroon? Okay.
Yes.
Senator Kroon.
Thank you, Madam Chair. And I'm speaking in favor of Senator Westrom's motion to amend the motion so that if we're going to pass it out of this committee, it is done without recommendation. Because I think that even if you agree with the intent of this bill, it is very poorly written as drafted right now. And as an example of that, if you just look at the last line, 114 to 116, businesses are also encouraged to identify, prevent, and reduce prohibited discriminatory conduct under this chapter. This is under the subdivision 9 notice to workers. Basically what this is saying is businesses are also encouraged to follow the law. And like, what are we doing? Like, that doesn't need to be in here. And the average business owner is going to be like, okay, there's this new requirement that I'm encouraged to do these things to follow the law. What does that look like? And so I just think that this product is not worthy of the Judiciary Committee to go out of here with recommendation. So if all we're doing is making sure that it goes to Labor Committee where this other amendment's going to be put on, and that it goes to Education Policy, I think for the Judiciary Committee to allow that to move, but also say, look, this bill is not recommended because it's not drafted in a way that's workable and that makes sense. I think that's appropriate. And it's still not clear to me when this amendment in labor is proposed, one, whether it will be adopted. We're making an assumption that it will. But I'm not sure all of these things that we're talking about are going to remain in the bill or if they're going to get taken out by the amendment. To me, that's like a critically important part of this. If at the end of the day, it's just a pre-printed notice that needs to go up in the break room, you know, that's one thing maybe Judiciary doesn't need to see it. But if any of this other stuff remains in the bill, it absolutely needs to come back. So I speak in favor of Senator Westrum's motion to amend the motion.
Okay, and Senator Westlin on the motion from Senator Westrum?
I'm going to vote no.
So just so everyone is clear, Senator Westlin has an underlying motion to move Senate File 3607 to be recommended to pass and referred to the Committee on Labor. Senator Westrum, you picked the two senators with W last names for me, but we got this. Senator Westrum has a motion to move Senate File 3607 without recommendation to be referred to the Committee on Labor. So we're going to take Senator Westrum's motion first. All right. All those in favor of Senator Westrum's motion, say aye.
Aye.
Okay. Opposed?
No.
Senator Westrum's motion is, the motion prevails and is adopted. So now we will move Senate File 3607 without recommendation to pass and to be referred to the Committee on Labor. All those in favor say aye.
Aye.
Opposed? Okay, that motion prevails and it is on its way to Labor. We do have some members who have committee at 3 p.m. So what I'm going to do is move to this last bill and we'll have a cutoff at 3 p.m. so members can get to that committee. We'll move to Senate File 3662.
Okay. Thank you, Madam Chair. This is Senate File 3662. In 1990, the Minnesota legislature first adopted disparate impact language into the Minnesota Human Rights Act, so this has been around for quite some time. Senate File 3662 revisits that language to update it to reflect modern issues in employment and housing issues, such as the use of AI in rental and hiring applications. I am going to once again defer to Commissioner Lucero, who will help us go through the bill, and she will be willing to provide any additional details that the committee has. I will say, actually, sorry, Madam Chair, I do have the A1 amendment as an author's amendment.
Members, we're just going to make sure we have a printed copy of the A1 author's amendment, if you can give us a moment. Okay, you have an author's amendment, Senator Westlin. We've got printed copies now. Go back to you.
Pardon me?
We have
Yes, I
the
do.
copies of the author's amendment, but
Okay.
I'll just go back to you to continue explaining the bill.
Thank you, Madam Chair. They really are just technical changes to the underlying bill. Primarily, the primary changes are changing the words person to complainant and adding an effective date. So I would move the A1 amendment.
All right, thank you. Senator Westlin moves the A1 author's amendment. All those in favor say aye.
Aye.
Any opposed? Motion prevails and the A1 amendment is adopted.
Thank you,
Okay,
Madam Chair.
to your bill is amended.
And Commissioner Lucero.
Commissioner Lucero.
Thank you, Chairwoman verbatim. So I appreciate the opportunity to present this bill today to keep civil rights strong in Minnesota, and I want to start by grounding this discussion in a few civil rights moments in Minnesota. So Minnesota's leadership on civil rights has not been a linear path. Our history in Minnesota is filled with nuance, missteps, and dark and painful periods. So for instance, Minnesota continued to allow slave owners to bring enslaved Black people into Minnesota long after this was prohibited under Minnesota's Constitution. For decades, Minnesota hotel owners continued to deny Black people access to hotel rooms, including in 1860 when even Frederick Douglass wasn't allowed to stay in the hotel room because he is Black. In 1920, thousands of Minnesotans, thousands, participated in the lynching of 3 Black men in Duluth. Many people aren't aware of this, but Minnesota was home to Charles Dite, a proud proponent of eugenics, a pen pal of Hitler, and someone who moved deeply harmful legislation for people with disabilities, calling for the segregation and sterilization of what he calls defective individuals. Minnesota subsequently decided to name a street after him. Like many states, Minnesota codified housing segregation directly into the deed covenants, which prevented Jewish and Black Minnesotans from buying homes in certain neighborhoods. And in 2022, after thorough and comprehensive investigation, the city of Minneapolis and MPD were found to engage in a pattern or practice of race-based policing, resulting in a subsequent consent decree with the Minnesota Department of Human Rights. I share all of this as we sit in the middle of another dark and painful moment in our state and nation's history. To that end, it's important that we safeguard Minnesota's civil rights laws, and I want to go over the specifics of this bill. So first, this bill is grounded in Minnesota's longstanding civil rights commitment and affirms a well-recognized legal framework that has been in place since the 1970s. And so, as Senator Westlin noted, it was 1990s when it was codified. However, it's actually been in place in Minnesota since the 1970s, as well as across the country. The framework clarifies the framework clarifies clear standards to better prevent discrimination in both employment and housing. The second thing this bill does is it details safeguards for legitimate landlords and employers by providing a clear defense where exploring and utilizing less discriminatory alternatives are utilized. And lastly, this bill modernizes the statute. It recognizes that AI systems are ever increasingly being used to screen job applicants and tenants. And while these tools can improve efficiency and consistency, they can also replicate or amplify bias and discriminatory outcomes, often at massive scale. So let me give a few specific examples to help illustrate what this case looks like or could look like. The first one's an extreme example, but it helps clarify it. So consider a local company decides to hire remote data entry employees. You're going to sit at your desk in your own home and you're going to put data into your computer. But the job posting states that this remote data entry employee must demonstrate they can lift at least 100 pounds. This policy would have a disparate impact, preventing many people with disabilities and also many women from getting hired for the position. In this hypothetical, I don't have any context as to why this happened. Maybe the employer borrowed from a position description they used for their warehouse staff and failed to take that out. Maybe it was intentional to keep out people with disabilities. I don't know. What I do know is it's an easy fix. The employer can simply remove the requirement, and these remote data entry employees can go on with their applying for the job without having to prove that they can lift 100 pounds. Now, here's an example that's becoming more common: the use of AI screening tools. In this example, we'll talk about by landlords. So consider a landlord is using an AI system to screen tenants. The AI tool screens out all tenants that cannot show proof of full-time employment. Now, of course, landlords need to see that a tenant can pay their rent. However, requiring someone to have full-time employment will result in a disparate impact on older Minnesotans who are retired and use their Social Security and retirement to afford rent. It will result in a disparate impact against Minnesotans with disabilities that are unable to work a full-time job but are otherwise able to afford rent from a Housing Choice Rental Assistance voucher. Again, this is a real easy fix. The landlord can require the AI tool to remove the question about full-time employment and instead properly screen for a potential tenant's ability to pay rent, which of course may include full-time employment. So at its core, this bill affirms a simple proposition. If a policy or procedure harms Minnesotans because of protected characteristics, we should examine that harm. And if a less discriminatory alternative exists, and if we can eliminate that discriminatory outcome, we should choose to do so. Now, I started out talking about this bill by providing examples of dark moments in Minnesota history when it relates to civil rights. And I want to highlight a few examples where Minnesota leaders, where legislators of both parties chose to prevent and end discrimination so that every Minnesotan can live their life with dignity and joy free from discrimination. So it's grounded in the core foundation of our Constitution. In May of 1858, when our state constitution was ratified, Minnesota chose to prohibit the practice of slavery, and we did this nearly a decade before the 13th Amendment was passed and ratified. In 1885, legislators responded to segregation and chose to pass the Equal Accommodation Act so that Black Minnesotans could access hotels, restaurants, bars. We did that almost a century before it was done at the federal level. And a little over a century ago, in 1921, legislators chose to pass anti-lynching laws following the brutal beating and lynching of those 3 Black men in Duluth. In 1989, Minnesota legislators chose to stop the horrific murders and violence against LGBTQ+ Minnesotans by passing criminal statutes outlining crimes that occur because of bias and discrimination. And this occurred more than 20 years before the government passed the Matthew Shepard and James Byrd Hate Crimes Prevention Act. Following this, in 1993, Minnesota became the first state in the nation to prohibit discrimination based on both sexual orientation and gender identity, because someone should be able to have a job regardless of their sexual orientation or gender identity. In 2026, today, you again have the opportunity to safeguard and strengthen state laws when passing this bill. Now, in the face of every challenge, Minnesota legislators, Republicans and Democrats alike, have declared that civil rights are foundational to Minnesota. You have chosen to recognize the humanity of all of us Minnesotans. And you have consistently stood against discrimination and for a Minnesota where opportunity is not limited by race, by age, religion, disability, or any other prohibitive factor. So this bill is an opportunity to reaffirm that legacy and to keep Minnesotans' civil rights protections strong. Thank you for your time.
We have another testifier, John Beeler from ACLU, if you want to come forward.
Chair, members of the committee, we are testifying today in support of SF 3662. Sorry, my name is John Beeler, Policy Counsel with the ACLU of Minnesota. I'm here to testify in support of Senate File 3662, the bill extending liability for discriminatory effects in housing and employment, which will greatly benefit Minnesotans. Disparate impact liability has long been a tool of civil rights advancement, beginning with the courts in the 1970s and Congress in the early 1990s. Last year, the federal government stepped back from defending these rights and eliminated the use of disparate impact liability, quote, in all contexts and to the maximum degree possible. Executive order, intentionally or not, misunderstood disparate impact liability, in which plaintiffs must show that they are challenging what they're challenging causes a significant or substantial statistical disparity simply to avoid having their case immediately dismissed. The burden then shifts to the defending company to show that a business necessity, and then finally back to the plaintiffs to identify a less discriminatory alternative. These cases are not easy, but when they are met, the plaintiffs have demonstrated that they did not have an equal opportunity to succeed, or alternatively, that they have proved discrimination. Disparate impact liability was used in its earliest forms to desegregate the public workforce in North Carolina and has been used recently to desegregate housing and access to housing in Louisiana and Texas. Minnesota and the Twin Cities Metro have some of the worst racial gaps in home ownership in the nation. These racial gaps also appear in employment, academic achievement, and poverty, particularly child poverty. We also appreciate that this bill addresses a modern gap in disparate impact liability, that created by artificial intelligence. AI tools and algorithms are created and trained by humans. They can be imbued with all of the biases and prejudices of their creators. Simply running those biases through an algorithm should not absolve a company of resulting bias in its output. We appreciate that this bill tackles the issue head-on and assigns liability based on the results rather than the human or non-human nature of the decision maker. The ACLU has long relied on disparate impact liability as a tool to remove systemic barriers to opportunity in housing, employment, and more for historically marginalized people. We believe this bill will make a meaningful difference in housing and employment access for Minnesotans. We urge the committee to support 3662. Thank you.
Thank you. Members, are there questions? For the testifiers. Okay. Are there questions to the bill? Nope, just those two. Okay. Come forward. I'm going to just begin by stating your name and title for the record and then continue your testimony.
Yeah, I'm Nathaniel M. Olson, the disability advocate for the state of Minnesota, and I just heard the most outrageous thing from the commissioner, and I kind of wanted to ask people in this committee, what on earth are you talking about slavery in the 21st century? This is 2026, and you're speaking about nonsense right now. What we should be actually worried about, people, is about this.
Excuse me, can I just interrupt for a second?
Yes.
I want to make sure you have the time to get through the rest of your testimony. At the beginning of this committee, we just went through some reminders of decorum for folks. I just want to give a reminder on just making sure that we have a really civil process here. And I would try to refrain from making comments directly at others. But I want to make sure that you have the time to go through the rest of your testimony. If you can just kind of remember the decorum that we ask for folks to follow in this committee.
Okay, so that's interesting. But let's talk about the human rights bill that people, they want to bring forward and how the committee decided that they didn't want to allow people to come that were pro-ICE here, but I just wanted to make something clear about something. And what our First Amendment in the United States Constitution is freedom of speech. So when we're limiting a certain group of people for freedom of speech, that's not right. I think it's very interesting when we have the commissioner talking about this, where we are looking at the most highest fraud in Minnesota. And I want to repeat what I said at the December 17th. Over 600,000 people with disabilities could suffer if we don't solve this. So I'm wondering when the Senate is willing to bring forth a fraud bill to tackle this, Because what I'm seeing right now is we're getting nowhere.
So we appreciate your testimony. We'll have the bill before us, so it's really helpful if you can keep your comments to the bill that is before us. And those questions about other bills that may come before, the Senate or other committees, we'll tackle those at another time. But I appreciate your testimony. And we'll go to members to see if they have any questions or comments at this
Yes,
time.
I had some questions.
You can ask questions of the testifiers or to the bill.
Madam Chair, I would appreciate, however, if the questions were actually related to the bill.
Yes. Senator Westrom.
Madam Chair, I didn't hear the beginning for the last testifier. What organization were you with? If you could repeat that, please.
Mr. Olson?
Yes, I'm a self-employed. I'm a disability advocate for the state of Minnesota. I started over a year ago, and I am the CEO of Nate Real Midwest podcast.
Okay. And Madam Chair.
Senator Westrom.
I guess I would say our committee probably should be willing to hear multiple opinions. Just because a testifier says he thinks it's nonsense, I don't think is a reason for you to be able to intervene in his testimony. And so I just would make note of that. I've got a question for the author. Can you tell us in like 2 sentences what you're trying to do in this bill? Because I'm reading the summaries, I'm reading the bill, and I'm listening to you. And I do not know. So could you just summarize this in 2 sentences so we know what we're trying to do as a committee here? Because this is not clear to me.
Commissioner Lucero.
Thank you. This bill simply further codifies.
Madam Chair, I asked the author of the
Senator
bill.
Westrom.
I understand that, Madam Chair. And
That's who I'd like to
I am
hear.
Senator
carrying
Westrom.
an agency bill, and I am going to defer to the commissioner to explain that the bill that the commissioner is putting forward for her agency.
Well, Madam,
Senator Westrom. Go ahead.
go ahead, Madam Chair. I'd like the author of the bill to be able to present that to us in coherent 2 sentences so we know what we're doing after the commissioner then, if we want to hear from the commissioner first. I think this is confusing to a lot of us.
I understand your question, Senator Westrom, but it's very common when we have a bill from our agencies to have the commissioner here to explain the purpose of the bill and why they're bringing it forward.
Madam
I'll go to
Chair.
Senator Westlin, and then I'll go
Very
to
briefly.
Commissioner Lucero.
Very briefly.
Senator Westlin.
Sir, are you done testifying? I think you could take your seat. Madam Chair, very briefly, the bill does impose liability under the Minnesota Human Rights Act in employment of real property when there is a discriminatory impact due to policies by employers. It removes the intent requirement, and that is my 2-sentence explanation of that, and I will have the commissioner provide some additional further information on that.
We're going to go to the commissioner.
Okay.
Commissioner Lucero.
Chair, more verbatim, Senator Westrom, this bill does 3 things. It clarifies the clear standards in place to better prevent discrimination in both employment and housing. It details safeguards for landlords and employers by providing a clear defense when they explore and utilize less discriminatory alternatives. And the third thing it does is it modernizes this statute by recognizing that AI systems are ever increasingly being used to screen job applicants and tenants. And this is just building upon what has been law in Minnesota since the 1970s.
Thank you.
Can I answer your question, Senator Westrom?
Better than the 10 minutes before that we got, but I'm still wondering who are you going after in this bill, Commissioner? I mean, give us some real live examples of what we're stopping. And I think one of the last testifier, I mean, I think it brings up a valid point. We've got a lot of people being affected by the fraud in this state, and we're dealing with this issue. So is this part of the fraud problem that we're trying to get to the bottom of? Or give us some real live examples, modern day, that you're referencing that you need this statutory change from 100 years ago to really get at the bottom of the problem. Give us some concrete examples, please.
You know, just a reminder that the Department of Human Rights has the ability to enforce the Minnesota Human Rights Act, but Commissioner Lucero.
Madam Chair, I'm going to ask if you can get to your microphone because you kind of tail off. And I know people like to hear what you say. I can barely hear, and I'm pretty close to you.
Got it. Thank you. My reminder, Senator Westrom, was just that the Department of Human Rights has the ability to enforce the Minnesota Human Rights Act. And we'll go to Commissioner Lucero.
Chair Umer verbatim, Senator Westrom, I think a perfect example is the one where I was talking about an AI screening tool used by landlords that require the AI system to screen tenants on whether or not they have full-time employment. So my mom was just recently looking for a place to stay, and my mom uses her Social Security and her retirement to be able to pay for her rent. And if there's an AI tool that screens out tenants based on full-time employment, the landlord would miss out on a phenomenal tenant in my mom. She keeps the place immaculately clean. That's an example in real life of where this is a very easy fix. The landlords can require the AI tool to remove the question about full-time employment and instead screen for potential tenants' ability to pay rent. That means my mom would have access to housing.
Senator Westrom.
And Madam Chair, Commissioner, do you have any other examples of this need across the state besides your own mother's situation that you think you're bringing this forward for? Can you give us some more? I mean, a handful?
Commissioner Lucero.
Chair Umer verbatim, thank you, Senator. I was trying to illustrate how it impacts each of us differently. So yeah, let me give you a different example. So for instance, a fast food restaurant that requires all cashiers to have a bachelor's degree. This kind of requirement is going to disproportionately limit opportunities, particularly for Indigenous and Black Minnesotans to be hired, because only 16% of Indigenous adults and 19% of Black adults have earned a bachelor's degree. Again, this is a really easy fix. The company looks at what it is that they actually need for the fast food restaurant cashier and can put those tests in place, removes the degree requirement, and allows applicants, for instance, to count work experience in place of degrees. You asked for additional examples. Let me also talk to you about an apartment building that has a policy in place that only allows 2 people to live in one-bedroom apartments. You can imagine this policy will have a disproportionate impact on families that have 2 people, more than 2 people in it. So for example, a couple would be evicted if they were to have a baby. We don't want that new family to not have housing. So again, this is a really easy fix. The apartment changes its policy to allow renters to stay in their units even after the child is born. Thank you.
Senator Clark has a question, and then I see Senator Holmstrom. Did you have follow-up, Senator Westrom?
Madam Chair, I just, a few more examples would be helpful, but I realize we're running out of time. Thank you for those examples. It gives us a little better flavor of what is being pursued and tried to be solved under this legislation. But I think there's way more questions to answer than what we're going to have time in this committee hearing for.
Senator Clark.
Thank you, Chair. Senator Westlin or Commissioner Lucero, in the buildup, you were talking about AI, and I think this actually follows up nicely to Senator Westrom's piece and some of the impact and results piece. So can you talk more about how the AI implications sort of will it exacerbate this in terms of the speed of proliferation of discriminatory aspects of how if we're able to keep up with this, or how you are able to think through the effects that AI may have on some of these pieces?
Commissioner Lucero.
Chair Umer verbatim, thank you. Senator Clark, for your question. So the AI tools are being used all over, and they have the ability to have a massive impact very quickly because they work at such scale. So the example that I gave there of being able to prove full-time employment, it's not just used by that one landlord. It is replicated across cities around the country. And so this one thing that I'm going to assume had no ill intent. The landlord just genuinely wants to know that the people that they're renting to can pay rent. Totally fair. But the people that it's impacting, people with disabilities, people, older Minnesotans, would be at scale. And so, again, making sure that those policies are not put into place, or if they are, that you've got this easy fix. Let's just resolve this on the back end here, so that we're preventing discrimination in Minnesota, which is the point of what we're here to do today.
Madam Chair, can I say one last thing?
Sorry, Mr. Olson, we'll call on you if there's questions from our committee members. You can stay nearby, and we'll call you forward if there's any additional
Okay, so you're
questions
just not
from our
going to let me
committee
just say
members.
one last thing.
That's just not how this works. If there's questions from our committee members, I'll certainly bring you back up to answer a question
All
from
right,
them.
that makes,
Okay?
thank you.
Senator Clark?
And in terms of the, for this liability to follow sort of the impact versus the results or the intent, are you able to parse those pieces out, or is that, why is it important for you to have that ability?
Commissioner Lucero.
Chair verbatim. Thank you, Senator Clark. So the courts rely on a variety of different methods to be able to determine this disparate impact. So statistical analysis is a common one that's used. It's not appropriate in all examples, but they're looking at what the impact is to prevent that from happening and to find remedies that can resolve it easily and quickly.
Senator Clark.
I think one more, but whenever you say statistical impact, it gets my little economics major brain going, and my all that fun that I had. I think I forgot to say Chairwoman verbatim and Senator Lucero. When you're looking at the statistical impact, Commissioner, I'm mixing my titles. I'm also new guy, Senator Holstrom, and I'm still learning the protocols of titles. But Senator Limmer says no.
Wow.
But he may remember when I interned here and goes, oh, man.
Wow.
Commissioner Lucero, when you're thinking about statistical impact, is it, within the office, or is it you're using external experts to find this? How do you employ the statistical impact model?
Yeah.
And just before I go to you, Commissioner Lucero, Commissioner, I just want to note we're at 2:56. We are going to end at 3. We're going to lay the bill over, so there will be time for further discussion. So I will go to Commissioner Lucero, and I know that you had your hand up, Senator Holstrom, so I will go to you as well. Commissioner Lucero.
Thank you, Chairman verbatim. Senator Clark. So these are very rare cases. They're hard to bring cases. And when you're bringing these kinds of cases, you are looking at a variety of factors. And so if you're relying on statistical data pieces, yes, people do use that they are relying on professionals who analyze those pieces holistically. Just because you have statistical significance does not mean you have a disparate impact at all. And so I don't like that in and of itself alone cannot be the cause for this. I mean, taking a step back, the purpose of this is not to identify where there's statistical problems on its own. The point of this is to prevent discrimination from happening. That's what we're trying to do. And if there's a policy or procedure that on its face is neutral, it may have had, again, that example of like, maybe they just accidentally moved over their position description and forgot to take out the piece about being able to lift a lot of weight for a desk job. Maybe it's intentional to keep out people with disabilities. Either way, there's an easy fix to resolve this by removing that from the position description and allowing anyone to provide that for the position based on what it is that is actually needed in that role.
Senator Holmstrom.
Thank you, Madam Chair. Commissioner Lucero, you had said that businesses need to, you gave a reference of a cashier at a restaurant not needing a bachelor's degree. And you said that businesses need to decide what they actually need. And I guess my question is, who is the arbiter of what a business actually needs? Because I've worked in small businesses my whole life. I own them. And it is often that you don't just have one title, you wear many hats. So your cashier may have the title of cashier, and your department may see that, but what if that person needs to wear more hats? I mean, who gets to make that decision?
Commissioner Lucero.
Senator, and we're verbatim, excuse me, Chair. Thank you so much for your question, Senator. So you are correct. Every case when it comes to discrimination cases are more fact-specific. And so I gave a very easy example to make a clear illustration. So if there is a position that requires someone to wear multiple hats, then again, hire for what it is that position needs. And so if that person has to, for instance, lift 100 pounds, please do put that in there. The issue is where these policies and procedures are resulting in disparate impact, and there could be less discriminatory possibilities in place. And so if you do want somebody who, for instance, is running your cashier, but they're also managing budgets, and you need them to be able to understand how to use Excel, a skill I completely lack, you want that position description to say that. I won't be able to get that position then. I have a college degree, but I don't have the required skills there. And so it is for the employer to determine what are the right procedures that are in place. They just need to do so in the least discriminatory way.
Senator Holmstrom.
Seeing it's 2:59, I think I'll leave my questions. Thank you.